It's a pretty interesting thing. It's extremely broad, but the Commonwealth has to prove beyond a reasonable doubt the core elements of an offense. For something like promotional or concealment money laundering, which you've heard me talk about in prior sections, there are a lot of elements. I think based on the elemental analyses I can kind of pull from the back of my head, 4, 5, 6 different things the Commonwealth's going to have to prove. I think in this third section, it drops down to like 2 or 3, which makes it potentially constitutionally infirm, but it's also kind of loose. It's not a federal cognate provision, meaning they didn't copy-paste it from federal law. So there's probably an open question as to whether or not it has the strength or force that a charge based on the same language as federal law would carry. So where did this thing come from? It is something that criminalizes when you are money laundering with funds that you knew or should have known were the proceeds of illegal activity. That should have known language is a bit unusual in the criminal context. Typically, you need to know some of the fundamental principles of the illegality of what you're doing for the court or the justice system to want to punish you for it. And this statute basically says if a reasonable person, it would have been obvious to someone who was paying attention that they were doing banking with illegal money, then you can get hooked here. This resembles something that comes up in federal case law a lot called willful blindness. There's usually always a component where the person for a little while is able to pretend that they're able to look the other way, put their head in the sand, pretend they don't know what's going on. Surprise, the law has tried to make an accounting for that, and that's what willful blindness is. We have willful blindness jury instructions in Massachusetts, but they have not been applied in a money laundering setting. What does any of this mean practically? You have an untested area of a particular criminal statute that is way easier to use than the other parts of the statute. So it could end up getting charged more, but it doesn't necessarily benefit from some of the stricter application of federal law as guidance. However, because it is based off stuff you see in a lot of federal case law, it may still have some teeth. So at this point, I think we're waiting to see if the SJC gets a case that runs off of that particular theory, which may be constitutionally infirm, it may not be, it may be just a huge hammer in the Commonwealth's arsenal. We'll see. When you are dealing with an area of law like this, which is so new and so unsettled, not only that, it's in the white-collar realm, and that's sort of hyper-specialized to begin with. It can help to have an attorney or a legal team that is equipped to handle these kinds of cases. You need people who can understand what's being alleged, first and foremost, and then you need people who know the ins and outs of the law and the best way to try and disassemble the case. If you've been charged with money laundering, or you're afraid that you may be charged with money laundering, call the law offices of Matthew W. Peterson, and we will be happy to guide you through the best possible defense that you can get. Stay informed, stay legal.